So we have been advising folks with respect to matters of discipline. If you're the accused, that you have to submit to the trial to keep your options open for an appeal and for the honor of religion. And if you are a member of a court, that you need to do this the right way, and you need to do it according to the book so that the outcome is validated. So what can a ruling elder who's sitting on a court in a session, or what can a person who comes and is accused of something, what can they expect by a trial? Will they be led in handcuffs? Will they have to wear an orange jumpsuit? Is there a bailiff with a gun? What can they expect?
Yeah, all of the above. No, well, first of all, they should read BCO 32, because that gives a lot of information with regard to this, and also BCO 35, because it talks about the trial itself. But let's go back to 32 for a moment, because after the indictment has been given and the accused has pled guilty, they set a date for the trial. The accused has a right to be represented. If the case is at the church level, session level, then any communicant member of that church can serve as counsel.
So I don't have to go about this alone by myself.
No.
I can get help.
It's right, and you should.
I should get help.
It's right.
You know the old adage, right? Anyone who represents himself is a fool, has a fool for a client.
Yes, right. And did you ever do that as a lawyer?
No.
You knew better.
I did, that's
okay,
right.
Yeah. But you were never charged either, right? So that was good. So yes, so I'm glad that you, as a recovering attorney, came up with that statement. So yeah, find somebody who at least can be there to guide you, if not even personally represent, because it's a frightening thing, daunting. We don't do this often in the church, so that's good. So you have the right to that. If it's at the presbytery level, it can be anyone who is at the member of that court. That means it has to be a ruling or teaching elder member of that court.
Now, there's something that's very important here. Someone can help you. You can't hire a lawyer to represent you like you can in the real world. So
exactly. That's 3219, which says that no professional counsel as such. So you can, if somebody happens to be an attorney and a communicant member of the church, then you can use his or her services, but you cannot hire and pay.
You can't compensate them for it. So it doesn't forbid all lawyers from being involved in this.
Exactly.
It's just that you can't hire someone and compensate them for representing you, which is a little bit odd because we're used to that exactly being the case in both civil and criminal court.
Exactly. We can't do that in the church. So once you go through the trial, the next thing is that you'll look at what the charges are, the specifications, and you can, if you have some doubts and questions, BCO 32-14 does allow you the privilege of inquiring of the court, asking questions, getting clarification to make sure that, do I have this right, or what about this, or I'm not sure about this list of witnesses because. So those things can be handled as sort of pre-trial, or when the trial begins, you can present your concerns or questions or motions in writing, but they should be in writings because you want a good paper trail, because if there should be a finding of guilt and you should appeal, the only thing that can go up as an appeal are what is in writing. And so a good record only can be in writing. So always keep that in mind.
Now, one of the differences between ecclesiastical court, our system, and criminal court is that if you are convicted, you can appeal that conviction. But if you are acquitted, someone can complain against the acquittal. And so what that means is the court has it in its best interest to make sure that as much is in writing as is possible. And perhaps the most important thing, which if it's forgotten, you can't go backwards in time, is that you need to record all of the proceedings, whether that's an audio recording or a video recording or both. Eventually, you'd need to produce a transcript, but you can't get a transcript if you don't have a recording of what was said and what was done.
And the other principle to that is the reason the transcript, if it should go up to the Standing Judicial Commission, they do not accept any audio or video recordings, only printed transcripts. So everything has to be in print.
Right.
So it's good to have if you write a memo to the court, if you are raising an objection, that you write it out, and of course it's being recorded, you'd have a written transcript. So that's just important to understand that no matter what kind of recording you have, that will not be reviewed without being transcribed in itself. So excellent point that, and the best thing to do is record everything. Some people say it almost sounds like you almost do the witnesses, the way it's in BCO 35, there's a phrase that makes it sound that way, but it's best just to let the tape run and allow for the whole process trial to be recorded.
Because of course, if you miss a moment, you can't go back and get it. If you end up with extra audio files or extra video files, there's nothing lost in that. Right. But if you needed something that the case might hinge on, then you'll have real problems.
Exactly. So next thing happens, again, BCO 35 guides in this, the witnesses, and the court is made up of usually a commission made up of 3 or 4 ruling elders, 3 or 4 teaching elders, depending on what that presbytery has appointed for that, and they together form the judge. They're the judges corporately and the jury, so they'll hear the case and decide it. And the case runs just like it would in a secular court. You have the prosecutor who presents the case with witnesses and any other evidences or representations and so forth. And then the defense has the right to cross-examine. Then when it's time for the defense to present a case, if they do, they have a right to present their witnesses, and they can also be cross-examined.
Now remember also that especially for smaller churches with smaller sessions, going through this process can be difficult because there may not be enough judges. So if you are a church that has 2 or 3 elders, and one of the elders is serving as the prosecutor, and maybe one might be a witness, you might not have enough judges. So you need to make sure, number one, that you have enough judges to hear the case. And there's a new provision in the book that if the accused tries to disqualify judges by calling them as witnesses, the court can say, well, this was not material witness that was needed, so we're not going to disqualify them. But you may find it necessary as a small church to get help. And one of the ways you can do this is that you can send what we call a reference up to the presbytery, basically saying to the presbytery, we don't have enough elders to form a valid court. Can you help us?
And that's BCO 41, by the way.
So can you send us a commission of 3 or 5 or 7 elders, a combination of teaching and ruling elders, to hear this case? And so if you feel like you're stuck in a spot, you can always go to the presbytery for help. Don't try to say, oh, we can't have a trial because we don't have enough people, or we're going to let the prosecutor vote on guilt. Don't try to fly by the seat of your pants.
Well, by the way, the prosecutor used to be allowed. Now, this last provision you just mentioned removed him from.
That's correct.
From that possibility. But the main thing here is this: the court has to give both sides the opportunity to present its case, the prosecutor and then the accused. And each can be challenged through cross-examination, and the court decides then the case after the fact. So it provides for a fair assessment and a good way for the truth to hopefully to come out and be made clear. So that's an important consideration. So that's basically how you would do it if you pled guilty.
You pled not guilty.
Not guilty, and you go through a trial. But what if you say, I want to plead guilty, or work with the court? There's a provision over in chapter 38.
So that should be easy. If someone pleads guilty, we shouldn't have to worry about anything, right?
No.
No, that's not the case. You and I have both seen many of these cases. It's sometimes more troublesome.
It can be if we're not careful. Absolutely right. So 38.1.
So 38.1 is what's called a case without process. It is not a plea deal. It is not like in the criminal realm where someone may commit a bank robbery and they will plead down to a lesser offense. And the prosecutor does that because they don't want to take the risk of losing a trial, and so they'll take that surefire guilty verdict. That's not what 38.1 is all about. What 38.1 is really about is the work of the Holy Spirit. and how the Holy Spirit convicts us of our sin. And when someone on their own initiative comes to the court and says, I have committed this sin, I would like to plead guilty, deal with me as you think is best and just for my spiritual growth. And so it's not a negotiating process. But the problem is that there's a very defined way to deal with this. And the way that is dealt with is the parties produce a statement. Typically, the accused will write out a statement of his or her sin and then gives it to the court and says, is this an adequate explanation? Do you think this makes sense? And sometimes the court will say, well, you didn't treat this aspect of your actions, or what about this? Can you add to it? Or this really isn't necessary, subtract that. And there can be some negotiation on that part, because really what you're aiming is to get at the truth. Right. And so you want to come to that simple statement. And when both parties agree to it, that's the statement that the judgment, the censure is made on, right?
And it has to be both parties agreeing.
Now, why do you think that is?
Okay, because if you're coming as your own accuser, you need to approve what they're charging you with. I mean, what they're going to eventually sentence you on. And number two, the court doesn't have to go through the whole process of trial and evidence and so forth. So they have to, and they know enough to say that we can accept or not accept how you develop this statement. So that's part of the reason for that, with regard to that. But what's important is that we cannot have two separate statements.
That's right.
We can't have two different allegations or a finished product, and both have to approve, and then the court can issue a censure.
And this is where simplicity is your friend.
That's right.
You get one statement, and both parties agree to this statement, and I would encourage both parties to say that in writing, to sign the statement, so they can, after the fact, say, we agree to this. And that's all that you present and talk about. You don't take the statement and then before the court say, and by the way, he beats his dog too. And so we really, you may think he should only be suspended from the Lord's Supper, but if you really knew about everything else he did, you would excommunicate him. And of course, the reason you don't want to do that is then the accused can't present a defense. Exactly. He doesn't know that he's even being accused of that.
Exactly. And we know that in the last number of years, there have been cases that have come all the way up to the Standing Judicial Commission where, unfortunately, with the simple steps that we've just gone through, were overturned. The case was overturned because the court didn't handle it correctly. And
that creates a further complication. Because if you go through the process where the accused accuses himself, essentially, pleads guilty, and the court finds a censure, and then that is overturned because this simple process isn't adhered to, then the question comes, how could a fair trial be held? Because we've already sort of had the man or the woman admit to guilt. We've already had the jurors, the judges, fined for a censure. And so the horse is sort of out of the barn and across the river already. So this is where you have an instance where not only have you made a mistake, it's hard to fix the mistake afterwards.
You can't go back and go through regular judicial process because you've muddied the waters.
You can't unring the bell.
Exactly. Yeah, you've poisoned the system.
That's right.
And so that's important. And so we would encourage, again, so we're repeating ourselves, but it's worth repeating. If you follow the steps as simple as they are, without complicating them, you save yourself a lot of grief and time later on.
And never forget, get help. When you're in this process and you're not sure if you're following the steps, ask someone who's been through it before and say, is there anything I'm missing here? Is there anything I need to add here? Better an ounce of prevention is worth a pound of cure.
See, now we've said this in all of these various tapings that we've done, and I'm hoping that if that nothing else, that will get clear. Get counsel and follow the rules.